$1,095.71. Court cost of $232. Total outstanding balance is $4,327.71.
All right. And Ms. Rosen, you don't represent Mr. Cook or Cook.
I do not, Your Honor.
All right, very good. All right, so go ahead. What do we want to do with this?
Well, if I may, Miss Escobedo has rent for March. The reason she's delayed in paying that is she had tried to pay it earlier in February because she has 4 children. She had to take to Washington State for a court ordered visit with their father. She was not allowed to pay it earlier. She's tried to pay it since and has asked that they waive the late fee and won't. So she can pay that on Monday if the late fee is waived. As far as April rent, she's submitted an application for state emergency relief. So she's asking for some time to pay.
Got it. So how much is her monthly rent? Yes.
I believe her monthly rent is $1,804.
So this is what I'm looking at basically is 2 months plus what may be some ancillary charges.
That's my understanding.
Okay. So is it that plaintiff won't take the February rent or she doesn't want to pay it without them waiving the late fees?
It's the rent for March, and yes, she's ready.
March.
She's ready to pay it if the $50 late fee will be waived. And then, as I indicated, for April's rent, she needs more time for the emergency relief to process.
All right, and here's what I'll do. I'll adjourn this out to the 18th. I don't have a full docket on the 11th. So I'll adjourn this out to April 18th, 2020. Got the money. Let's try to get it paid. All right.
And Attorney Rosen, if you want to reach out to me in the meantime so we can try to negotiate something.
Absolutely. Yep. I will reach out to you later today.
Okay.
And if she's done the SCR, we would need to have the rental assistance form to the court by Wednesday.
This Wednesday.
Tracking.
Okay.
Yes. All right.
I will get that to the court. Thank you so much, Your Honor.
Thank you.
Have a good morning.
You do the same. Michael Troon, not checked in. You paid for second service. If you'd raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right. Go ahead.
Thank you, Your Honor. At this time, we would motion the court for a default judgment for possession only, where the outstanding rent to retain possession is $1,297.62. Court cost of $183. Total outstanding balance is $1,480.62. We are asking for a pay or vacate date of April 14th, 2025. And I do a test. Hold on, Your Honor. I'm sorry. I think I read the wrong numbers.
Okay.
We're on C1071, Your Honor.
1071. Yes, ma'am.
Okay, yeah, $620.97 for a cost of $183. Total outstanding balance is $1,803.97. We're asking for a pay or vacate date of April 14th, 2025. And I do attest to the best of my knowledge and belief that Mr. Truhan is over the age of 18, a competent adult, not deployed on active duty in the military, and that we have kept the unit fit for habitability.
All right. Judgment to the plaintiff. That is by default for possession, redemption amount, any amount requested with a writ issue in 10 days. Westridge Mobile Home Park versus Johnny Lewis.
Gabriel Lacey for Westridge.
Johnny Lewis, not checked in. You may proceed.
Thank you, Your Honor. At this time, we will be requesting a default judgment for possession only, where the outstanding rent to retain possession is $1,297.62. Court cost of $183. Total outstanding balance is $1,480.62. We are asking for a pay or vacate date of April 14th, 2025. And I do attest to the best of my knowledge and belief the defendant is over the age of 18, a competent adult, not deployed on active duty in the military, and that we have kept the unit fit for habitability.
Judgment to the plaintiff. That is by default. For possession, redemption amount, any amount requested with the writ issue in 10 days.
Thank you, Your Honor.
Court does call the case of Sosita Management versus Ricky Noble.
Gabriel Lacey for Sosita Management.
Ricky Noble, they are not present. You may proceed.
Thank you, Your Honor. At this time, I believe with got a note on this file, Your Honor. I do not believe that service was perfected on this file, Your Honor, and so we are asking.
I have. Oh, yeah, they filled in. Okay, they have no service made.
So if we could just adjourn today's hearing, so that we can perfect service.
Got it. Adjourn the matter to April 18th, 2025 at 12. Well, yes, at 12 p.m. Well, no, we wouldn't do that if I'm adjourning for service. It's going to be a first hearing. Do you know what time?
Yes, I'm sorry. Let me open the appropriate document.
Okay. 18th at 10 a.m. That will be by Zoom.
Thank you, Your Honor.
All right. Thank you.
I believe that's all for me. Have a wonderful day. Go Tigers.
All right. Yes, indeed. Take care. Arbor Knoll versus Sita versus Malakia Beverly versus Jose Amaya versus Thomas Kearney, Park at Sagebrush versus Thomas Kearney, and Celine Mobile Home Park versus Joshua Everly. Those matters are dismissed on plaintiff's motion without prejudice. All right. Thank you. Valley Ranch versus Brandon Kuchar. And also Carolyn, is it Migda?
Migda, she is not present though, but Brandon Kutcher here.
All right.
Sorry, Your Honor. Casey Matson, P87729 on behalf of plaintiff.
All right. And what is plaintiff's claim in this case?
Your Honor, I have rent to retain of $4,263.49, cost of $182.00, for a total of $4,445.49.
Okay, Mr. Kuchar, what do you have to say about that? How are you intending on getting this paid?
She's not here, but I was hoping to have this adjourned to the 11th or the 18th, whatever fits your schedule, and we'll have payment made in full on or before the 11th. So I guess by the 10th, so that it's in there before we were to meet again.
All right. My next date that I really have a docket that I can do on this will be the 18th. I'll grant you an adjournment to the 18th, 2025 at 2 p.m. Escrow,
2 p.m.
given that adjournment is reserved. Yes, 2 p.m. That's in person. If it's paid, check with the attorney's office. They may just dismiss the case out.
Okay, thank you so much, Your Honor. Thank you, Ms. Matson. Have a great day.
Thank you, Your Honor.
Thank you. Spice Tree Apartments versus Samuel Bishop.
Casey Matson on behalf of the plaintiff.
Samuel Bishop. There is no response. If you'd like to take a default, raise your right hand. Sir?
Samuel Bishop.
Okay, he's here. All right, he's dialing. All right, what is plaintiff's claim in this case?
Your Honor, I have rent to retain of $2,485.62, cost of $189.00, for a total of $2,674.62.
All right. Mr. Bishop, how are you intending on getting that paid?
Yes, I plan to have it paid in full around the 18th. I had my wallet stolen from out our complex parking lot last weekend, and it kind of threw my plans in disarray.
What I will do is I'll reserve escrow at this point. I'll adjourn to my next available date, which is the 18th, April 18th, 2025 at 2 p.m. That's an in-person hearing, sir. If you have it paid before that point in time, you need to contact the attorney's office, make sure they may dismiss the case, but everything would need to be paid. Understood?
Understood.
All right. Thank you.
Thank you, Your Honor.
Court calls the case of Spice Street Apartments versus Cameron Hall and Latwana Mitchell.
Casey Matson on behalf of the plaintiff.
Hello, do I have Cameron Hall? Yep, looks like I do. Hello, I can't hear you, I don't think.
Oh, hello.
Hello, what's your name?
Cameron Hall.
All right, very good. What is plaintiff's claim in this case?
Your Honor, I have rent to retain of $3,096.40. Court costs of $182.00 for a total of $3,278.40.
And Ms. Hall, how are you intending on getting that paid?
I have no idea.
Okay, have you applied for any assistance?
No.
All right. Would you like an opportunity to do that?
Yeah.
Okay. Did you see the video that played before the hearing advising you of different resources?
Yes, I did.
All right. $18.99.
Thank you.
All right. Do that. And why don't I do this, Ms. Hall? Well, let me ask this. Is there anything that you can pay between now and the 18th?
I could pay something, but it probably wouldn't be a lot.
Okay. How much do you think you can pay?
Probably anywhere between 300 to 500.
300 to 500?
Yes.
All right. I'll put in the file 300 to 500. When would you be able to make that payment?
By the 18th.
By the 18th? Okay, you have to pay it by the 18th prior to the hearing time. So I'll adjourn this then to the 18th, 2025 at 2 p.m. That's an in-person hearing. Okay?
Okay, thank you.
All right. And what I'm going to do is I'm going to put you into a breakout room with our court liaison officer, Amy, that you speak to her about resources that might be available to you. Okay?
Okay, thank you.
All right. Thank you. So hold on the line. Good morning, Amy.
Good morning, Your Honor.
Your Honor, is she paying that into escrow or just directly to my client?
I'm not sure. Send a message that she's to pay the funds directly to the landlord. All right.
Thank
All
you.
right. You're welcome. All right. Whitaker Oaks versus Gene Zimmerman.
Casey Matson on behalf of the plaintiff.
Gene Zimmerman. All right. Now you can raise your right hand. We can go with that oath. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the true self you got?
I do.
All right. Go ahead.
Thank you, Your Honor. We're requesting entry of a default possession only judgment. Rent to retain is $1,625.43. Court costs of $200 for a total of $1,825.43. Writ to issue in 10 days.
Judgment to the plaintiff, that is by default for possession redemption amount in the amount requested. Writ to issue in 10 days. Whitaker Oaks versus Randy Widener.
Cents. Court cost of $239.00 for a total of $1,910.59. Writ to issue in 10 days.
Judgment to the plaintiff by default for possession redemption amount in the amount requested. Writ to issue 10 days. Whitaker Oaks versus Marjani Green.
Casey Matson on behalf of the plaintiff.
And Daniel Keener. And Miss Green's here. Hello.
Good morning.
All right. How much is owing on this?
Your Honor, I have a total rent to retain of $2,440.16. Cost of $239.00 for a total of $2,679.16.
Ms. Green, how are you intending on getting this paid?
I have an prevention appointment with Hawk scheduled for April 18th. They said that they would assist me with the balance.
Okay, you have an appointment with Hawk?
Yes.
That's on the 18th?
I mean, I'm sorry, not the 18th, the 16th.
Oh, you have it on the 16th. Okay.
Yeah.
So what I'll do on this matter, have that on the 16th. I'll reserve escrow in this matter. I will adjourn this case out to April 18th, 2025 at 2 p.m. That's an in-person hearing.
Okay.
And then we'll see exactly where you are with Hawk. Since you're particularly you're under the 3,000 mark, it looks promising. Okay?
All right. Thank you, Judge.
Thank you. Whitaker Oaks versus Kristen Davis.
Casey Matson on behalf of the plaintiff.
I'm here.
Okay, what's your name?
Christian Davis.
All right. All right. What is the
A total of $2,118.16.
sir? How are you intending on getting that paid?
I have the money. It was just a issue with my payments not going through because of something not updating the DTE and not getting the DTE payment. I guess just the rent couldn't get processed, so I should be able to have it by the 18th.
Okay. Is there anything you can pay before the 18th?
Yeah, I should be able to pay it in full as soon as possible.
Okay. So what day can you pay it in full?
Friday payday.
The 11th?
Yes.
All right. I'm going to mark the file that you're going to pay the balance by the 11th.
Okay. They she said, the lady at the office said something about, I just talked to her yesterday. She said to come up there and it's just a few things that she needs me to do, and then I guess she'll lift the eviction notice or something.
Well, what will happen is that if you pay it in full, I'm sure they'll contact their attorneys to dismiss the case.
Okay, got you.
Other than that, I don't know what she could be talking about.
Right.
But I'm going to
okay.
put in here, you're going to pay the balance by the 11th. I'm going to indicate that escrow is reserved. I will adjourn the hearing out for April 18th to April 18th, 2025 at 2 p.m. If the balance isn't paid, you'll need to appear in person, sir.
Okay, April 18th,
2 p.m.
11.
All right.
All right, thank you.
Okay.
Appreciate it, Your Honor.
Okay. Thank you.
All right, bye-bye.
Sylvan Crossing versus Aria Cummings Jones.
Casey Matson on behalf of the plaintiff.
Cummings Jones, they're not checked in. You may proceed.
Thank you, Your Honor. I have rent to retain of $884.33. Cost of $194.00 for a total of $1,078.33. Would be requesting entry of a default possession only judgment, writ to issue in 10 days.
Judgment to the plaintiff by default for possession, redemption.
Is $2,153.33. Cost of $194.00 for a total of $2,347.33. Writ to issue in 10 days.
Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested. Let's issue in 10 days.
Thank you, Your Honor.
Thank you. Have a great weekend.
You as well.
Court does call the case of Wayne Dockett versus Dennis Heyman.
Good morning, Your Honor. Stacy Denzer appearing with and on behalf of Wayne Dockett. We're appearing by Zoom.
All right.
Good morning, Your Honor. Kimberly Hammond appearing on behalf of Dennis Hammond.
All right. And it's a non-payment of rent case. Plaintiff, how much is claimed owing?
The same 4,500 that's owed by the other tenant. It's a joint and several liability, so we're trying to get it from one or the other.
Okay, so $4,500.
Yes, sir.
All right.
Your Honor, we've disputed the charges on a number of bases, filed a counterclaim, an answer affirmative defenses, a jury demand. And so I saw the last proceeding, even though I was not notified of it. I also tried to look up the case that was cited in C2 of the complaint, which it doesn't exist. Never received a notice to quit. I received something from Attorney Dinser the other day, which looked like a notice to quit that said it was personally served. It was never personally served. So he never received a notice to quit. I believe, Your Honor, they're trying to double dip, and they've never really even formally evicted this person.
Well, he's moved out on his own. He's no longer there.
Do you have a written statement from him or anything that says that?
Nothing of his is there. The apartment is empty, and he's gone.
And how do you know that?
So Mr. Heyman is gone?
Because I've been in the apartment.
Okay.
Mr. Heyman's gone?
Yes. That's why we didn't sue for possession on that one.
He didn't know about any of these proceedings until he got this complaint. Via first-class mail, I might add, from your court. And apparently it's for money damages, which he should have been personally served.
I did serve him personally.
Where at?
First
I
of
mailed
all,
it in, Your Honor, and the mail is really horrible. I've mailed it to the courthouse.
all right. Well, all I'm going to tell you,
He
I
wasn't
don't
in the
have it.
courthouse.
So
Mailed it to the courthouse.
I think she's saying that she mailed the proof of service to the court.
Yeah, but I know he wasn't at the courthouse. I know he wasn't.
He was. I saw him. I handed it to him.
On what day?
The day that Bria was there. The day we were there with
Folks,
Bria.
hey, folks, I'm not going to sit here and listen to this. You guys can either figure out how to argue this out or whatever. But the issue is not possession, correct?
Correct.
Or counsel, are you aware of that or what?
I was not aware of that, no.
Well, the complaint's for money only, not possession. Because he's already out. The apartment's empty.
Well, then my question would be, why wouldn't this be a GC case?
My question as well.
Well, because he's owed the money on the landlord tenant. He's owed the rent. So they're jointly and severally liable. I'm not trying to double dip. I'm going after both people on a joint and several lease. If whatever I get from Ria,
All right.
we would take off of what's owed
So if somebody would mind answering my question, it'd be nice.
Should be plaintiff.
Why wasn't this filed as a general civil action as opposed to a landlord-tenant case?
In the end, Judge Simpson refused to rush to judgment, ordering another hearing because too many procedural questions remained unanswered. The fight over unpaid rent took a back seat to a much bigger issue, whether the case had been filed, served, and handled under the correct legal process.so. Who do you think has the stronger case when they return to court, and will procedure decide the outcome before the facts ever do? If you enjoyed this courtroom breakdown, hit like, subscribe for more real courtroom drama, and watch our next case where one unexpected ruling changes everything.